Good morning. This is Sue Klein, co-president of the Clearinghouse on Women's Issues, with Jan Erickson, the other co-president. And Jan is going to introduce Jeanette, who's on the phone, and take it from there. Go ahead, Jan.
Thanks, Sue. Well, as she mentioned, I'm Jan Erickson, longtime feminist activist around town and in my home state, Alaska, which I heard has had 6 feet of snow recently. But I do welcome everybody to the Clearinghouse. This is our very first program in 2024, and it's a very critical subject, looking at what we need to do about our courts, especially the Supreme Court. For today's program, we'll only be discussing this for 60 minutes. That's going to be the time that we're going to move to for the rest of the year, at least. And we have an incredible line of distinguished speakers. And Jeanette will introduce those folks. As we've seen, the increasingly conservative U.S. Supreme Court seems bound to overturn many of the progressive gains of recent decades. The public has noticed this. Polling shows about half of Americans view the court unfavorably, who also describe the court as corrupt and unaccountable. 48% say the court is taking away their freedoms. What can we do about the court and other federal courts? Well, we're going to find out with the two speakers that we have today, Chris Kang and Rebecca Buckwalter-Poza. So we are very thankful to get such high quality speakers. I'm going to introduce our also very distinguished moderator, Jeanette Lim Esbrook, a longtime CWI member, vice president for legal affairs for CWI. She will lead the discussion. She is a career civil rights attorney and has held an array of top positions in the federal government. As a Justice Department attorney, she litigated numerous gender and race cases, including the admission of women to South Carolina's Military College of the Citadel, very famous case. Jeanette was Deputy Assistant Secretary in the Office of Elementary and Secondary Education in the Department of Education, overseeing federal aid to local education agencies under Title I. She's also served several times as Acting Assistant Secretary in the Office of Civil Rights Department of Education. And her policy work there included seminal efforts in the Title IX sexual assault, sexual harassment policy development, and Title IX requirements for equity in intercollegiate athletic programs, very key to all of our work under Title IX. So Jeanette, who's had some technical problems, but is nonetheless going to conduct the moderation by phone. Jeanette, take it away.
Yes, thank you, Jan. This is an interesting topic today, which is SCOTUS, the Supreme Court of the United States. Today, as Jan mentioned, the court's reputation is at an all-time low. Our speakers will address possible responses to the court's credibility and their ethical challenges, which are many. In the meantime, this is an important term, and the following significant issues will be addressed by the court. I'm going to mention 3 of them, and there are many more. The first one is the eligibility for the presidency of the United States. Section 3 of Article 2 of the Constitution has the following requirements for the presidency. They are age 35, a natural-born U.S. citizen, and being a resident in the United States for at least 14 years. What is before the court, however, is Section 3 of the 14th Amendment. That section prohibits from public office anyone who has been found to have engaged in insurrection or rebellion. The second issue that is before the court this term is presidential immunity. The rights of the president are defined in Article 2 of the Constitution, and immunity is not discussed. However, the potential candidate for the presidency, Mr. Trump, has claimed that total immunity does exist for the president. Court will address this issue, or maybe not. And the third issue, and finally, is the authority of the administrative agencies in the executive branch of the government. Under a 40-year precedent known as Chevron, the agencies have interpreted the congressionally passed statutes, and during this term, the court has been asked to decide whether this continues to be good law or whether the interpretation of the congressionally passed statutes should be left to the court. Those are several of the important issues facing the court today, and there are others. The court, as we are learning, is also facing credibility challenges, and that will be discussed. Addressing the credibility challenges will be addressed by the speakers today. As moderator, let me give you a order of our program. The two speakers, as Jan mentioned, are Chris Kang and Rebecca Buckwalter-Poza. I will introduce them in order of their presentations. After their presentations, we will have a question and answer period, so please hold your questions to the end and enter them into the chat as they come up. Let me introduce our first speaker, Chris Kang. Chris is the co-founder of Demand Justice. It is an advocacy group that advocates for progressive change in our judicial systems, something he will address today. Chris was invited to testify and did testify before the Presidential Commission on the Supreme Court. He served in the Obama White House for nearly 7 years and oversaw the selection, vetting, and confirmation of more than 220 of the president's judicial nominees. He helped spearhead the confirmations of Supreme Court Justices Sotomayor and Eleanor Kagan. Chris also served as National Director of the National Council of Asian Pacific Americans and worked for the U.S. Senate Democratic Whip, Richard Durbin of Illinois, as Director of Floor Operations, Judiciary Committee Counsel, and Counsel for Labor Issues. Demand Justice first endorsed Supreme Court expansion in 2018. I'm going to turn this over to Chris now to tell us about some of those issues of Supreme Court resolution. Chris.
Great. Thanks so much, Jeanette, for that introduction and setting the stage for the conversation. And thanks in particular to Jan and Sue and CWI for inviting me and Rebecca to talk about this. And I think that it's very appropriate that this is the first conversation of 2024, especially as we head into a presidential election year, because I think so many times once the calendar turns to the presidential election year, that's where all the focus goes. The focus goes to the White House, the focus goes to Congress, and the courts too often are left behind in the conversation, where I really do think that they need to be at the forefront. And I think that they need to be part of all of the advocacy and strategy and thinking that we do around how to advance progressive change and how to preserve our democracies, because at the end of the day, as we've seen time and time again, the final word is held by the court. And so I know that all of you are very engaged and active on a lot of these political issues, And so I hope you'll indulge me, though. I'm sort of do this at a little bit of maybe not 30,000 feet, but maybe like 10,000 feet. And so some of this may be obvious to you, maybe ways that you've thought about it, but sort of over the time that I've worked, I sort of spent, as Jeanette said, I spent the first 2/3 of my career so far in government, in the Senate and in the White House, and then the last 7 or 8 years out of government. And I think it's sort of brought me a different and maybe unique perspective in sort of how I've thought about the courts and how I think that all of us should be considering the courts. I think that it's easy for us to understand that what the Supreme Court is doing these days is wrong. And again, I think the polls sort of show the plummeting support amongst the public. But when I think about what's really wrong with the court, it's not just the decisions. It's really what's motivating and what's leading to these decisions. And in particular, I think the two main problems with the Supreme Court today are that it's too political and that it's too powerful. I think, you don't have to look any further than yesterday being the anniversary of Roe versus Wade to understand what the Supreme Court is doing. It's not just Roe and reproductive justice. It's making it harder to do anything about gun violence or climate change. It's striking down affirmative action. It's ruling for corporations 60-70% of the time. All of these decisions are being politically motivated. I also think it's worth taking a moment to recognize that as bad as these decisions have been over the last couple of years, and as many of there been over the last couple of years, this is not just a problem of this current Supreme Court with a supermajority of Republican justices. It's certainly gotten worse. But when you think about the way that this court over the last 20 or 30 years has thought about democracy, the court has always been an anti-democracy institution. When you look at Citizens United, when you look at Shelby County versus Holder, where they struck down part of the Voting Rights Act, you look at how easy they make it for political gerrymandering, where politicians get to choose their voters rather than voters being able to choose who represents them. And you start to look at, of course, going all the way back to Bush versus Gore, this Supreme Court for a long time has been politically motivated. And by politically, I mean pro-Republican and pro-corporate and sort of pro-special interest. And I think that that is a very important way for us to understand the court, because I think like a lot of us, when I grew up and I learned about the court system in elementary school, I was taught that the Supreme Court is not political. It's not, it's meant to be independent and impartial. And that's, I don't know if it was ever true in the history of our country, but it's certainly not true today. And it hasn't been for a long time. And I think that that's important for us to recognize. And as Jeanette said, the court is setting itself up to do even more damage, whether it's access to medication abortion, LGBTQ equality, sex-based discrimination, these important democracy cases on the 14th Amendment and immunity for the president or former presidents. And again, the last case Jeanette mentioned, and sometimes we talk about the power of administrative agencies and people don't quite click on just how important that is, because it's not as easy to understand as whether Trump should be on the ballot or not, or whether president should have absolute immunity for anything. But to really understand what that case is, right now, when Congress passes a law, the executive branch is empowered to execute it. They make up all of the smaller rules to implement and enforce these regulations to make the laws have real effect. And for a long time, as Jeanette said, 40 years, the courts have deferred to these executive branch agencies because they have the expertise to put these policies in place. And now we've seen Republican justices poised to take that power away from these longstanding agencies and give it to themselves. And the reason they want to give it to themselves is that they can strike down these regulations that keep us safe, that allow worker safety and fair pay, that protect our civil rights, that protect our environment. All of these pro-democracy, pro-consumer, pro-individual regulations that these agencies are putting forward to effectuate the laws that have already been passed by Congress, the courts want to strike them down. And so that is a huge, huge case that's going to be coming up. They just had oral arguments, so it'll be decided by June, that can really tell how much power we're going to give to the courts. And I think that that is the other piece that I think it's worth understanding, is that the courts are not just too powerful in terms of the impact that they have on our daily lives, but they're becoming too powerful when we think about the balance between the branches of government. Again, we sort of think back to this idea of checks and balances, that when one branch of government gets too powerful, the other two are supposed to come in and restore some balance. That's not happening today. Right now, we have a judiciary that is grabbing more and more power for itself at the expense of, so they're saying, Congress, you want to pass the voting rights law? No, I'm going to strike it down. The president wants to enact change around climate change. I'm going to strike that down. States want to do something through their legislatures to fight gun violence prevention. I'm going to strike that down. The FDA tries to allow medication abortion because it's been proven safe for decades. I'm going to try to strike that down. The courts are becoming more and more powerful. And I think the way to really see just how powerful they are is the corruption that we're seeing with respect to the lack of ethics and accountability in our courts. There are conflicts of interest. You sort of look no further than Justice Thomas ruling on cases regarding the insurrection when his wife was engaged in them. We have connections to billionaires, not just Clarence Thomas, but also Neil Gorsuch. Connections to billionaires, and they're hearing cases in which these billionaires are either parties or have very clear monetary interests in them. So they're refusing to recuse, and they're refusing to even disclose the benefits they've received. And so while billionaires fund Justice Thomas's lavish lifestyle, he won't even disclose these as gifts in what I think is clearly a violation of federal law. And it's a violation of sort of what we would expect in terms of ethics when it comes to our courts. But the problem is that the Supreme Court of the United States is literally the only court in the entire country that does not have an enforceable code of ethics. Why? Because they're so powerful. They've said, don't worry, we don't need one, and nobody stepped in to enforce one on them. Finally, I think you can get a sense of just how powerful these Supreme Court justices are and think they are, or should be, that now you started to see after the Supreme Court's ruling in Dobbs, upending access to abortion across the country, Supreme Court justices are going on tour complaining that there's criticism for their ruling. They want to not only be above precedent, above the rule of law, above any ethical standards, they want to be above criticism itself. They want to be able to hand down these opinions and say any criticism of us is inappropriate because we're judges. And that really is sort of, I think, one of the big indications of the problem we have with this Supreme Court in general, is that the problem is not just the makeup of the court. It's certainly not great that there are 6 Republican appointed justices and 3 Democratic ones, but the institution itself has become far too powerful and far too isolated, and it's in need of reform. And so when we think about, just briefly, like, how did we get here? This has been, a 50-year project in the making. A lot of the activism around the court started after and in opposition to Brown versus Board of Education and desegregation. It started with opposition to Roe versus Wade and access to abortion. And in particular, during that same time, there was a big effort among the corporations and the Chamber of Commerce to grab more power through the courts for themselves. And it is really this combination of racism and misogyny and corporate interests that has really been building over the last 50 years in a concerted effort funded by corporate interests, dark money, billionaires, sort of combined with some of the social activism felt by a strong minority of this country to put Republican focus on the courts, while at the same time, Democrats have not been politically engaged on the courts. Again, from an institutional perspective, we've spent a lot of time, generationally, spent a lot of time defending the Supreme Court, defending the court's decisions, whether it's in Brown or in Roe or in Obergefell, defending the court when it does things to expand our rights and expand liberty. But two, we sort of have been a little bit allergic to having a political conversation about the courts, because either we don't think the court should be political, or we sort of look at what the other side has done for so long and thought, we don't want to stoop to their level. We don't want to make the courts political. We don't want to be like them. So we'll sit this fight out. The problem with sitting this fight out, however, has been that one side is ramping up the politicization. They're ramping up the activism around the court. And if we sit it out, that doesn't like level it out so that the court's less political. It means that it's very political on one side, and the conversation is almost silent on the other. And that's why this conversation today, that's why this entire movement is so important. And the good news, as Jeanette said, is that polls are starting to show that the understanding of our courts are changing. More and more Americans believe that the Supreme Court's making its decisions based on politics rather than the law, which is to say, more Americans are having an accurate understanding of how this court is acting. But that is what we need, and we need now finally have more Democrats disapprove of the Supreme Court than approve of it, because then you sort of have the ability to push for change. And so as we think about change, there are a lot of different possible changes that the court could make, and I think should make. I won't go into all of them because some of them are a little bit detailed about, how many justices it takes to hear a case, or what cases the court should hear, and things like that, which I think are important reforms. But I think there are three in particular that are sort of the most important, the most talked about, and probably the most likely in the we'll call it midterm rather than near term in terms of change. The first is Supreme Court expansion. The size of the Supreme Court is not set by the Constitution. It's set by a simple act in Congress. In fact, the Congress has changed the size of the Supreme Court 7 times before. And so it just takes a simple law to change the size of the court, and we could change it. We could change it today. There's legislation that's been introduced in both the House and the Senate called the Judiciary Act of 2023 that would add 4 seats to the Supreme Court. Literally, the bill is about 1 page long, and you essentially cross off 9 and you insert 13. That would restore balance to this court immediately. And that would provide an opportunity for President Biden to add 4 justices that would, depending on your view, they would offset the extreme ideology of the justices that are on the court today, or they would offset the theft of these seats that has happened over the last several years when President Obama was denied the opportunity to seat Merrick Garland, or Garland didn't even get a hearing. He was replaced by Neil Gorsuch instead. And then President Biden was denied the opportunity to fill the seat left by Justice Ginsburg, and it was filled by Amy Coney Barrett instead. Those 2 seats that were illegitimately filled, the way to offset the impact of them and restore what should have been is to add 4 seats on the Democratic side. We should be, by sort of normal order, have a majority of Democratic appointed justices. And so expanding the court can bring balance back to it. And that then, I think, is a gateway to all of these other reforms. And in particular, the next big reform that's often talked about is term limits. Supreme Court justices currently serve for good behavior, or in the case of even Clarence Thomas, even longer than that, because they need to be impeached, even in the face of mounting evidence of crimes and unethical behavior. And so one proposal out there is to have 18-year term limits. And 18-year term limits would, I think, again, reduce a little bit of the power of the courts. If justices could not decide, like Anthony Kennedy did, exactly when to resign so that they can be appointed by a successor. That's sort of the same ideology of that. And also, so these term limits sort of provide some regularity. The idea around term limits is that every president would be able to appoint 2 justices in his or her term. So then you have a little bit more regularity. It's not just that Presidents Clinton and Obama get 2 justices in 8 years each, and then Trump gets 3 in 4 years, that there's some uniformity, and the court therefore will then begin to reflect a little bit more of the national will as expressed through these presidential elections. And so have that be one way of reforming the Supreme Court and adding some more turnover. The concern with term limits is that the life term of Supreme Court justices, of all judges, is set in the Constitution. And so there is a debate. There is a debate among legal scholars, and there are a lot of legal scholars, both progressives and conservatives, who say, actually, there's a way you can pass a law to change the terms to 18-year terms by just a law, without a full-on constitutional amendment. We all know how hard it is to pass a constitutional amendment. These professors, bipartisan, think you can do it by just passing a law. The challenge is, as we see time and time again, the people who determine whether a law is constitutional is the Supreme Court. And these Republican justices have not spent 50 years to amass all of this power for themselves to simply give it away, to force themselves into only 18-year terms. But if we had Supreme Court expansion first, you have then a majority of justices who will at least be open-minded to these legal arguments and give reforms such as term limits a fair chance. And so I think that is another important but not sufficient change to the court. I think some people say, well, I'll support one reform rather than the other. I think the challenge with term limits is that term limits doesn't actually help us today, right? Giving Brett Kavanaugh another 15 years on the bench is not going to be the thing that saves our Supreme Court today. And so we need to think about how to do these reforms in tandem. And then the last one, which probably has the most near-term likelihood, is an actual enforceable code of ethics. I think that a code of ethics is incredibly important as a response to the unethical behavior that we've seen by justices, as a bare minimum to restore some level of confidence and credibility to the court overall. And most importantly, I think it would show that Congress and the president are willing and able to step in and start to, again, restore that balance of power between the 3 branches of government. The way to have an enforceable code of ethics is for Congress to pass a law. That's all it takes. And yet, so far, Congress has been unable or unwilling to. And so I think that this is sort of a baby step, but I think we need to understand that passing ethics reform isn't enough. That sort of forcing Clarence Thomas to disclose which millionaires and billionaires have been funding his yacht trips is not going to lead to more progressive or pro-democracy decisions. It's not going to restore the balance that has been stolen from us and stolen from the country over the last 2 administrations. It's not going to help bring about a government that's more responsive and reflective of the people's will. And so again, these are sort of I think we need to get out of the mindset that you should or could only support one or not the other. I think that all 3 of them are 3 important pillars of reform, and they're all necessary in order to start to right-size the institution and bring about a lasting change for the court that is a little bit more balanced. The last thing I'll sort of say around the courts is that we spend so much time always thinking about the Supreme Court, which is, of course, the one that dominates the news and has the final word and is so important. But there's so much activism and focus we need to have on our lower courts as well, federal district courts and federal circuit courts. I think that you think about the impact of these lower court judges on our democracy, and we sort of look no further than in Florida, where a wildly unqualified young Federalist Society acolyte is ruling on one of the Trump cases with respect to his handling of classified information, to understand, like, all of these federal judgeships, they're all lifetime judgeships. They all consider almost all of these cases that go up to the Supreme Court start at a district court. They work their way up. They're all so important. And I think that one of the important things to think about is is who sits on these courts. And one of the big changes that's happened from my time in the Obama White House to today is President Biden has been able to not only focus on demographic diversity with the most people of color, women, LGBTQ judges in history, but also on professional diversity, bringing forward more public defenders, more union side labor lawyers, more lawyers who have represented individuals, civil rights lawyers, rather than corporations and the government and prosecutors. And I think this is an incredibly important place to advocate for change as well, in which a lot of our senators have a say. Our senators have a say in who gets recommended for these judgeships in the first place, and not only in the confirmation of them, which is also critical. And so I know that Rebecca is going to talk more about the lower courts and the work that her organization is doing around advancing professional diversity, but also structural reform around the lower courts, which I think is incredibly important. And also, we're just fortunate to have AFJ and their leadership around ethics and other reform as well. But again, I sort of have talked for probably longer than I was supposed to, but really appreciate the opportunity to sort of give a big picture view about sort of the challenges that are facing us today, as well as some ways that we might be able to push for change and sort of the specific changes we need to be talking to our friends, our neighbors, and ultimately our members of Congress about eventually enacting. So thanks again for having me.
And thank you, Chris. We look forward to following the issues that you raised that are currently under consideration by Congress, by several congressional and Senate representatives and senators. We look forward now to Rebecca Buckwalter-Poza, who is our next speaker. She is the Aaron Senior Justice Counsel at the Alliance for Justice. She is an advocacy attorney and is best known for successfully suing the 45th President, Trump, of the United States under the First Amendment with Columbia University's Knight First Amendment Institute. Rebecca has worked on several issues, including making justice equal at the Center for American Progress, covering the Supreme Court and the federal judiciary at NPR with legal affairs correspondent Nina Totenberg, and worked on originating the role of judicial affairs. She is the judicial affairs editor at Daily Cause. She is also co-founder of PRISM, a publication that elevates stories, ideas, and solutions from the underrepresented leaders, thinkers, and activists whose voices are critical to a reflective democracy. Rebecca received her AB from Harvard College and her JD from Yale Law School. She's a student of military law who observed at Guantanamo. Rebecca clerked for the Honorable Margaret Ryan on the U.S. Court of Appeals for the Armed Forces, as well as clerking for the late Juan Turella at the First Circuit Court of Appeals. I'm going to turn this over to Rebecca.
Thank you so much, Jeanette. And thank you to Sue and Jan and Chris. I am delighted to be joining you today. Even if it's on a somewhat sad note, the deterioration of the federal judiciary and justice in the country right now. When I joined Alliance for Justice last April and joined the federal courts team, we were joking, wouldn't it be, isn't it going to be a great day when Clarence Thomas just says, you know what, you're right, I've crossed the line, I'm just going to step down. And that, unfortunately, very quickly lost its humor. And it has only become more true that the Supreme Court is aware of the legitimacy crisis that it both inherited and precipitated with the 6-3 uber-conservative majority. I mean, we can take, for example, I know Chris touched on a number of these things, the fact that even Kavanaugh and Coney Barrett have made public statements, or did in the lead up to their false code of ethics, a PR exercise, saying that they supported the Supreme Court taking measures to reform its ethics obligations. Unfortunately, the code of ethics that they released did not do that. There's no mechanism for accountability, and the language of the code of ethics that they released significantly changes the language from which they borrowed, the code of ethics that applies to the lower federal courts, as well as model language from the ABA, among other sources. And what do those changes look like? Changing shall to should, for example, when it comes to provisions that should be binding, on things like reporting recusals or recusing in the first place. And the details of some of the ethics crises bear highlighting. I mean, this is nothing new. This is Justice Thomas, many years ago now, was called out by the Los Angeles Times for having failed to report spousal income. And as Chris mentioned, this is particularly concerning in the case of Justice Thomas, given what his spouse does, which is lead the conservative movement from the Tea Party to January 6th. And that makes it particularly galling that he has not reported accurately or timely her involvement and her earnings. But of course, Thomas isn't the only one. Chief Justice Roberts' wife is making money from the very law firms who come before the Supreme Court, and that's a problem too. And again, not just Thomas, who has accepted some of the most high-profile perks of any of the justices in the forms of private trips by yacht and by jet from major conservative donors and individuals who have significant interest before the court. It's Justice Thomas and Justice Alito, or no, sorry, Chief Justice Roberts and Justice Alito own individual stocks that in and of themselves create financial conflicts of interest and have failed to enumerate the reasons for recusal when they have recused, in the case of Alito, or to simply move forward with a reform that is enumerated in several of the pieces of legislation targeting Supreme Court ethics, which is to say, giving up the individual stocks. But the Supreme Court, unfortunately, has been unwilling to undertake a more meaningful step toward the code of ethics or toward the enforcement of ethics, which leaves us with the possibility of enforcement through, as Chris suggested, Congress or potentially through DOJ. If the Administrative Office of the Federal Judiciary were willing to address the ethics concerns, they too could be players. But unfortunately, we have yet to see that. And of course, one of the, also related to Chris's notes, one of the big problems facing the judiciary isn't even about judges' ethics, but about the overburdening of the judiciary itself and the backlog of cases. Given the number of cases that go to federal courts and the current number of justices appointed, or judges and justices appointed. And until the 90s, it was a fairly routine matter for the number of judgeships to be expanded proportionate to the caseload that the federal judiciary was undertaking. But just as the right has challenged all precedent and just the simple day-to-day functioning with respect to who gets to nominate and fill judgeships, as in the case of the Supreme Court openings, the right has also blocked the expansion of courts proportionate to the caseload that the federal judiciary is taking on. And that's a problem not just writ large for the total caseload, but because there are these single judge districts in states, For example, Matthew Kaczmarek is an example of how when you have a single judge district or very few judges, that creates a judge shopping problem, where the far right knows exactly where to file their cases and claims to get the results that they're hoping for politically. And the expansion of the judiciary would help not just with balancing ideologically writ large, but hopefully with these specific districts that are currently being abused by activists on the right. This attack on the federal courts is, I mean, the inaction that amounts to an attack on the federal courts is contributing to the loss of faith in not just the Supreme Court, but the judiciary as a whole. So we would hope Alliance for Justice has advocated for the expansion of the courts as a matter of just logistics, in addition to the repairs that need to take place for public faith in the judiciary and its functioning to be righted. And that is, I will pivot from the lower federal courts to also highlight the importance of state courts and some of the jeopardizing initiatives from the right that are affecting the state court's ability to deliver justice as well. And I think it's clear there's a long-term investment on the right in judicial elections at the state level and in legislation to reshape state legislatures that is now becoming a particularly pronounced issue. So we've seen since Dobbs public outcry, and that the right, when it attempts to consign abortion to a ballot initiative, is not succeeding as they hoped that they would. So their runaround effort is to then reshape the judiciary state by state, which is why there were 40 pieces of, well, there have been so far at least 40 pieces of state level legislation targeting abortion rights in 23 states since the Dobbs ruling. And why it is that the right is undertaking attacks on judges that aren't in line with their political desires at the state level, like Judge Janet in Wisconsin, after a liberal majority was elected for the first time in 15 years. As with Anita Earls, an African-American woman on the Supreme Court of my home state, North Carolina, who was attacked through a mechanism for judicial ethics after she made a comment regarding diversity in the judiciary. So the right's not even pretending to actually have an ethical qualm or issue. They are simply going after judges for not being conservative. And that's how we've arrived at this place where, and I know President Obama was fond of it, but the statement from Martin Luther King Jr. about the arc of the moral universe being long, but bending toward justice. And we've arrived at a place where conservatives view justice as a threat. And that's very concerning. And their state level initiatives are particularly problematic after COVID, which hit state courts harder than federal courts in terms of compromising their ability to adjudicate issues quickly and to be effective. 95% of cases go through state courts rather than the federal courts, which is another reason to be concerned. And both in federal courts and at the state level, there's another structural issue. In addition to attacking judges for their political views or for simply stating DEI-related observations, conservatives have been restructuring the courts and changing what type of judge here's what type of case, and expanding courts at the state level under Republican governors, even as they're refusing to expand the federal judiciary because there's a Democratic president. And these structural changes are an enormous threat. And going back, so both state and federal courts, one aspect of this is the push toward arbitration, which privileges repeat players and those who are able to throw a lot of money at litigation, and also prevents the adjudication from creating precedent. that can be used on behalf of the other individuals and parties who might seek resolution through the courts in the case of, say, consumer protection. And all of that puts justice further out of reach for most Americans, and is in and of itself an argument for the expansion of the judiciary and the creation of meaningful ethics regulations or a code that actually has a mechanism of accountability. And I would also say that some of the coverage has disappointingly suggested that there's a both sides element to ethics infractions or transgressions at the Supreme Court in particular. And it's just not the same. It's apples and oranges when Justice Kagan is worried about getting free bagels and Justice Thomas is gallivanting around the world on private jets and yachts and accepting Bibles worth 5 figures. And having major conservative developers buy, for example, his mother's house and allow her to continue living there with the notion that they would eventually turn it into a museum celebrating Thomas or sending his grandnephew to school, and so on and so forth. And we've seen also Justice Thomas actually using the court itself and hosting a reception there for one of the various organizations and networks with which he's become involved by his own request. One of my favorite Thomas revelations in the darkest sense is that he himself was the one who simply stated and invited his benefactors to assist him financially because he felt he wasn't earning enough on the Supreme Court. And I look forward to any questions. And again, I'm really delighted to be joining you today. Thank you all so much.
Thank you, Rebecca.
I have a question for Rebecca, who wrote a really fantastic article for Ms. Magazine recently about how overloaded the lower courts are and how Congress has really not addressed the problem of the need to update the courts in like 30 years. And we now have 40% more people in this country. And there are hundreds of thousands of cases that are backloaded. Rebecca, could you comment a little bit more on that?
Sure. So the last time that Congress acted to expand the courts for the reason of continuing their smooth functioning was 1990 and the Judicial Improvements Act. And at that point, they added, in addition to permanent judgeships, 13 temporary judgeships in order to respond to the backlog. And of course, there are 94 district courts, 12 circuit courts, or 13 circuit courts, and a total of 179 appellate judgeships and 673 district court judgeships. And that's just not nearly enough. From 1990 until today, as you addressed, the population of the United States grew by almost 40%, and yet the federal judiciary has not grown. And as did the state courts, having taken a greater hit during COVID also means that more cases are likely being rerouted into the federal courts. But it's a problem that only Congress can fix, and it's well overdue. So Representative Johnson is the one behind the motion to recalculate the number of judgeships that are needed based on filings and population, and also in support of a term limits bill that would, so as Chris mentioned, one solution or sort of related solutions are expanding the number of seats on the Supreme Court or creating term limits. And one variation on that is term limiting status as an active justice of the Supreme Court and saying after 18 years that you have to take senior status, which would be a different approach to expanding the court that could potentially attract more support and accomplish many of the same aims.
Great. Thank you, Rebecca. You've obviously spent a lot of time thinking about how to address this problem.
Yeah.
Yes, go
Sorry.
ahead.
I would add one thing, which is so the lower courts to give perspective, in addition to the need to expand, part of the reason for that, there's the logistical reason, and then the political, which is Trump appointed 234 lifetime nominees to Article 3 judgeships. So these lifetime appointments at the district and appellate court level. And Biden is now 168 nominees in, where Trump had been 187 by this point. Although, of course, as Chris alluded to, the professional demographic diversity has been remarkable and is something to hang on to, where 2/3 of Biden's nominees have been people of color or women. And that's a very big deal. But we are falling behind. And so Trump having deliberately appointed extremely political judges, that is the thing that we most need to balance out.
Great, good point. I see that Karen Humphreys has mentioned a book that I also have been reading, along with maybe 5 other ones I'm trying to get through at the same time, from Senator Sheldon, who has done a lot in uplifting the problems of the conservative effort to take over the courts. His current book is entitled The Scheme, which describes how the conservatives took over the court system primarily for corporate interests, and especially to the work of the Federalist Society. And I'll let Chris in just a moment comment on this, because I know he's well grounded in this area. There have also been analyses that say that corporate interests have effectively captured the highly emotional anti-choice activist mob, I'm going to use that term, as a means to push their overall agenda in deregulating business, especially for corporations. So at any rate, Chris, if you care to jump in and elaborate a little bit on that.
Yes, I will do that. And then I see that Lois has a question about whether or not if we expand the court on one side, it'll continue. And I think these are maybe a little bit related. I do think that Senator Whitehouse is absolutely right, and and Karen therefore as well. In terms of the confluence here between anti-choice. We're also seeing now anti-affirmative action, anti-DEI racist elements that are propelling Trump are also in on this, and corporate interests. They're all aligned in this particular manner that I think is a little bit. They have more in common than you might originally think, which is to say they're all about special interests, and they're all about using the courts to capture as much power for a small minority of the country to impose their views upon the rest of us. And when you think about issues like access to abortion, gun violence prevention, climate change, these are what I call 80-20 issues. 80% of American people support doing something about them, 20% don't. And the same is true when it comes to corporate power, whether corporations should be held accountable for defective products or discrimination, or be allowed to continue merging and having greater monopolies and greater control. You look at all of these things, and the American people want more corporations to be reined in. Republicans and conservatives are using the courts to impose the will of the 20% on the 80% of us. And that is very important. And I think one of the challenges then is not only are these corporate interests being very effective in funding a lot of the social issues to take the grassroots role in terms of projecting out how much conservatives care about the court. One of the challenges then is that a lot of these very important economic cases just don't get as much attention. When you think about every June, when you think about the coverage of the court, they're always around these social issues. And there's no question that these social issues are incredibly important, but they're not so important that we shouldn't also be talking about the way that this court is ruling. This is the John Roberts Supreme Court is the most pro-corporate court in generations, because there's this confluence of interest and support. And so I think it's very important that we lift up the economic impact of the court is having as well. But then this gets back to Lois's point. I do think that if the Judiciary Act passed tomorrow and President Biden appointed 4 Democratic appointed justices, the next time Republicans get power, they probably would try to expand the court and add another 4, 8, 10 justices of their own. And like, I think that one of the things to realize is that that's not going to be like an endless tit for tat back and forth, because I think we've seen that it's very different for Democrats to expand and reform the court, to bring balance, to restore our rights, to restore freedom, reproductive freedom, being safe from guns, doing something about climate change, doing something to rein in corporate power. Democrats would be expanding the court to do those positive things. If Republicans then expand the court to take all of that stuff away, you'll see the same backlash that we're seeing in state after state after state when it comes to abortion being on the ballot. This is not a back and forth many times. I think it's a back and forth once. Republicans, if they ever do gain power again, which I think with a more balanced Supreme Court and therefore a more fair democracy with greater voting rights, less gerrymandering, will question whether or not Republicans will get the trifecta and be able to expand the court. But even if they do, the backlash will be so much that Democrats will be able to come back in and restore balance once again, and that'll probably be the end of it. I'll also add just 2 other points on this. One is that even if it did just go back and forth for all time, we're in a much better position for that period of time in which we're in our favor now, as opposed to the alternative, which is for the next 30, 40, 50 years, we're not going to have a majority. And that is going to be something that is going to have such a negative impact on our democracy and our country. In the meantime, we have to be thinking, what is something that I can do? What is everything that I can do possible? What is every tool in the tool belt? How can I push for it? And how can I seek to advance change? And that's why expansion is important. And the last thing I'll say is, like, a lot of folks think like Supreme Court expansion is super controversial. It's not very popular. If we talk about it, maybe we're going to alienate people. Poll after poll shows not only is the Supreme Court approval at the lowest level it's ever been, not surprisingly then, support for expansion is the highest that it's ever been. Almost a majority, sort of more people support expansion than oppose it. And in some polls show literally a majority of people support expansion, including 70% of Democrats. And so we can't be afraid, as I feel like sometimes we often are. We're afraid of our own shadow. We're afraid about talking about the things we believe in because we're afraid about alienating people who may not agree with us. Supreme Court reform and Supreme Court expansion in particular are widely popular, particularly among Democrats. And I think we need to start speaking and reacting from this position of power in order to effectuate change. The question that Holly has here about what congressional committees would be responsible to reform the court, it's the Senate Judiciary, the House and Senate Judiciary committees are the ones that have the most jurisdiction. We have seen under Democratic leadership when Hank Johnson and Jerry Nadler led the House Judiciary Committee and Subcommittee on the Courts, we saw a lot of hearings. We saw a lot of hearings on Supreme Court reform, on term limits, on rights, on expanding the lower courts, as Rebecca has mentioned. We've seen a lot of effort in the Senate recently to talk about oversight with respect to ethics. And the Senate Judiciary Committee at the end of last year, under Senator Durbin and Senator Whitehouse's leadership, has now issued subpoenas to Harlan Crow and Leonard Leo to try to follow the money and see where it goes. So we're seeing a little bit of this focus and attention on the courts, but not nearly enough. I will say that it is important that their Judiciary Act has been introduced in both chambers of Congress. There are only 3 senators who support it right now: Ed Markey, Tina Smith, and Elizabeth Warren. On the House side, there are only about 60 some odd House members who support it. And I think they don't support it, not because they don't believe in it, but because they haven't had the time or need to focus on it. And I think that that is where the activism of organizations and individuals such as yours is so important, because the more these members of Congress hear that Supreme Court reform is important and that expansion is important, the more they're going to find the time it takes to look up the bill, look into the issue, and go and get on this bill. Even though it obviously is not going to be passed anytime soon, I think we need to start building the momentum and getting people engaged sooner rather than later.
Great. Thank you, Chris. Well, we have our work cut out for us, obviously, to get more members of Congress lined up behind reform. I noticed that Rebecca has added some important statistics. Rebecca, do you just want to comment quickly on those numbers? They're pretty staggering, actually.
Yeah, sure. No, and that's just to your question earlier about how serious the backlog is, and what it means for COVID to have had an effect on how quickly cases can be adjudicated and what's brought in federal versus state court. In the first year of the pandemic, there were 400,000 pending cases in the federal courts. And by the second, there were nearly 600,000 cases pending in the federal courts. So the Judicial Conference made an adjusted recommendation, so it perhaps wasn't even as significant as what it might have if politics were not likely to determine the viability of its proposal. Even that sort of watered down proposal from the Judicial Conference said that we need at least 2 new appellate judgeships and 66 new district judgeships, as well as making most of the temporary judgeships previously created permanent, just to respond to the number of cases that the judiciary is facing already.
Wow, that would be great if we could only see that happen. I think it's going to take an awful lot of citizen activism to prompt members of Congress to do something. In the meantime,
Absolutely.
I think we've heard from everybody who's going to offer a comment in the chat. So I want to thank Chris, who's just been really wonderful and telling it like it is, and Rebecca. So unless there is any other question or comment, I'd like to sign off and thank Jeanette for moderating. Thank you for everybody for attending.
Yeah, same here. It was a very informative session. Thank you, Chris and Rebecca. I'm
Thanks so
signing off
much.
too.
Thank you all.